Hi madam, my name is Vashi Ramdas and alongside with my group members are going to present about the application of contract law principles in IDA against Cepat Sihat Sendirian Berhad and others. I'll be the first speaker followed by speaker 2 Madhura, speaker 3 Vinay Sharma, speaker 4 Arif Haikal, speaker 5 Yakeshwaran and lastly being concluded by me again. Today, I will be discussing the first issue in our case study, which is the dispute between Ida and Cepat Sihat Sendirian Berhad regarding the Immunipatch advertisement. The facts are straightforward but legally significant. Cepat Sihat advertised a 10,000 ringgit reward for anyone who used their patch daily for 30 days and still developed a severe skin allergy. To prove they were serious, they even deposited 10,000 ringgit with June Bank. Ida, a nurse with sensitive skin, relied on this, bought the product and followed the instructions. Unfortunately, she developed a serious rash within just 3 weeks. When she tried to claim her reward, the company refused, calling the ad a promotional gimmick. Therefore, the core legal issue we must address is, did this advertisement constitute a binding unilateral offer that became a contract upon Ida's performance? To answer this, we look at the established contract law. The primary authority here is the landmark case of Khalil against Karbalik Smoke Ball Company. The case established that an advertisement promising to pay money in return for the performance of a specific act can indeed be a binding unilateral contract. Furthermore, for the contract to be valid, there must be an intention to create legal relations. Under Section 2A of the Contracts Act 1950, an offer must be made with the clear intention of being legally bound once accepted. The law tells us that if an advertisement is clear, specific and backed by evidence of sincerity, such as the deposit of the money, it moves beyond a mere invitation to treats and becomes a firm offer. Now, let's apply these principles to Ida's situation. First, the advertisement was not vague. It specified the reward of 10,000 ringgit and a specific condition of use. Most importantly, the company's deposit of 10,000 ringgit at June Bank is a statement of sincerity that mirrors the fact in the Khalil case. This effectively destroys the argument that the ad was just a gimmick. Secondly, Ida accepted this offer through conduct. In unilateral contracts, the offeree does not need to call the company and say, I accept. The act of buying and using the product as directed constitutes acceptance. Even though she developed the rash in 3 weeks rather than full 30 days, she was performing the required act in reliance on their promises. In conclusion, based on the principles of Malaysian contract law and the precedents set by Khalil, a valid unilateral contract was formed the moment Ida began performing the conditions of the advertisement. Cepat Sihat Sendirian Berhad cannot hide behind the claim of a promotional gimmick. They are legally obligated to pay Ida the 10,000 ringgit reward. Our advice to Ida is to insist on payment immediately, and if the company continues to refuse, she has a very strong basis to take legal action for breach of contract. Thank you.
The situation given is an agreement made between Rahman and his close friend Johan. So they agreed that if their children marry each other, each father would give RM50,000 to the couple as a wedding gift. So the marriage did take place and Rahman fulfilled his promise. However, Johan passed away before making the payment. So when Ida and Afis attempt to claim the Rm 50,000 from Johan's estate, the executor refused to claim. So the issue is whether Ida and Afis as a third parties can enforce the promise made between Rahman and Johan to pay Rm 50,000 upon their marriage. This slide will discuss about the law that could apply in this case. So under the doctrine of privity of contract, only parties that involve in a contract can enforce the terms, and third parties has no rights to sue even if the contract was made for their benefit. The principle was clearly illustrated in the case of Twill against Atkinson. In that case, an agreement was made between the father of a couple that each would pay a sum of money to the groom upon the marriage. The marriage took place, but one of the father died without making the payment. So when the groom tried to sue the deceased father's estate, the court held that he could not enforce the promise because he was not a party to the contract. Applying this principle to the present case, the agreement was made only between Rahman and Johan. So although Ida and Afis were intended to benefit from Rm 50,000 ringgit of wedding gift, they were not parties to the agreement, and they did not provide any consideration. So even though the promise was made for their benefit, under the doctrine of privity of contract, Ida and Afis cannot enforce the agreement against Johan's estate. Applying the law to the fact, the agreement in this case was made solely between Rahman and Johan. Ida and Afis were not involved in the forming of the agreement, and they did not provide any consideration. Although the promise was made for their benefit, they are only intended beneficiary and not parties to the contract. There is also no evidence that the agreement created a trust in favor of Ida and Afis. Nor is there any agency relationship. As such, none of the recognized exceptions to the doctrine of privity apply. As a result, the executor of Johan's estate is justified in refusing the claim, as Ida and Afis have no enforceable contractual rights. In conclusion, the agreement is enforceable only between Rahman and Johan. Since Ida and Afis are third parties to the contract, they cannot enforce the promise of Rm 50,000. Therefore, under the doctrine of privity of contract, the claim against Johan's estate fails, and the executor is not legally obliged to make the payment.
Very good day, madam. Today I'll be presenting my analysis on issue 3. The legal question we have to answer here is simple but significant. Was there a binding contract between Ida and her mother? As we know from the facts, Ida's mother promised her a monthly allowance of Rm 2000 if she quit her nursing job to study law full-time. However, when they had a disagreement later, the mother stopped paying. So the issue we must determine is whether the promise made by Ida's mother to provide her a monthly allowance of Rm 2000 until she graduates created a binding contract between them, or it's just a family agreement which is not a binding contract. To answer this, we have to look at the legal element to intention to create a legal relations. To solve this, we rely on two landmark cases that establish the general rule and the exception for domestic arrangements. First, Let's look at the general rule found in Balfour against Balfour 1990. In this case, a husband promised to pay his wife a monthly allowance while he was working abroad. When he stopped paying, the court held that that was not a contract. Why? Because the court presumes that in domestic arrangements, like between a husband and wife living happily, parties do not intend to be attended by legal consequences. These are promises based on natural love and affection, not legal duty. However, we must strictly contrast this with our second case, which is about Merritt against Merritt 1970. Here, the court took the opposite view. They held that the agreement was binding. The crucial difference was the context. The husband and wife were already separated and the marriage had broken down. Because the circumstances were serious and hostile, the presumption of domestic harmony didn't apply. There was a clear intention to rely on the agreement legally. Okay, now let's apply these principles to Ida and her mother. On the surface, Ida left her nursing job. However, we must look at the nature of relationship at the time the promise was made. Unlike Merritt, Ida and her mother were not in a hostile legal dispute when this agreement was made. They were in a normal parent-child relationship. Ida's mother promised to pay Rm 2000 was essentially a family arrangement to support her daughter's education. Crucially, as noted on the side, there was no formal or written agreement. They didn't sign a contract, they didn't involve lawyers, and they didn't write down terms of repayment or consequences of default. When the mother stopped paying, she argued that family arrangements aren't contracts. Based on the lack of formality and the domestic nature of the relationship, the fact aligned much closer to Balfour than to Merritt. There is insufficient evidence to show that the mother intended to face a lawsuit if she stopped the allowance. In conclusion, the promise made by Ida's mother is likely to be domestic arrangement rather than an intention to create legal relation. Therefore, there is no binding contract between Ida and her mother, and Ida's mother was not legally bound to continue paying Ida her monthly allowance, despite the promise made by her mother.
Assalamualaikum warahmatullahi wabarakatuh and good evening. My name is Arif Haikal bin Saiful Idris. Today I will be presenting the issue 4, which concerns about the government scholarship bond. In this case, Ida entered into 5-year scholarship bond with Ministry of Health. After serving only 2 years, she resigned to work overseas. The government demanded repayment of the entire bond sum. The illegal issue we need to consider is whether this repayment clause is enforceable under Malaysian contract law or whether it amounts to an unfair penalty. The relevant law comes from both statutes and cases law. First, Section 75 of the Contract Act 1950 provides that when a contract is breached and a sum is named as payable upon breach, the party complaining of the breach is entitled to reasonable compensation, not exceeding the amount stated. Second, the Contracts Amendment Act 1976, particularly Section 4 and Section 5. It specifically addresses about scholarship agreements. In the Section 4 confirms that scholarship agreements are valid even if entered into by minors. Section 5 goes further, stating that if a scholarship agreement is breached, the scholar and their sureties are liable to pay the whole sum named in the agreement, regardless of whether partial service has been performed. So, there are 3 cases law that supports this position. Firstly, in the case of Government of Malaysia versus Kuchara Singh 1971, the court held that education and training provided under a scholarship bond were considered necessaries and repayment was enforceable. In Muslim of Malaya versus Lee Min Chong 1986, the court upheld the repayment obligation under a scholarship bond. On the other hand, Selva Kumar vs. Tiaga Raja 1999 clarified that penalty clauses must reflect actual loss, but this principle is limited when scholarship agreements are governed by the Amendment Act. Applying the law to Ida's situation, her scholarship bond clearly falls under Contract Amendment Act 1976, which makes such agreement enforceable. The clause requiring repayment of the entire sum may look like a penalty, especially since she already served for 2 years in the Ministry of Health. But normally, the Section 75 would restrict recovery to reasonable compensation. However, Section 5 of the Amendment Act overrides this by allowing the government to claim the full amount named in the agreement, regardless of partial service. From Aida's perspective, she can argue that the clause is punitive and unfair, relying on the reasoning of Selva Kumar, but from the government's perspective, public policy strongly supports enforcement. The government invests significant funds in training scholars, and repayment ensures accountability and prevents abuse of public resources. Therefore, the courts are more likely to side with the governments. In conclusion, the scholarship bond is legally enforceable. Aida is liable to repay the full scholarship amount despite having served 2 years in the Ministry of Health. Her argument that the clause is a penalty is unlikely to succeed because the Contract Amendment Act 1976 specifically protects scholarship agreements. So, my advice to Aida would be to negotiate with the Ministry of Health for a possible settlement or partial waiver, but legally she must repay the bond. In this case, it highlights how contract law balances fairness with public interest, ensuring the government scholarship are not misused.
Good day, madam. Today I'll be presenting about the issue 5 of the question, which is involving offer, counter offer, and acceptance. First, let me briefly explain about the fact of the case. In the scenario, Aida planned to buy a house in Seremban from Laila, who is a property agent. Laila offered to sell a house for RM 500,000. However, Aida replied by offering RM 450,000 instead. This response is known as a counter offer. Laila then rejected Aida's counter offer. A few days later, Aida changed her mind and wrote back saying that she agreed to buy the house at RM 500,000, which was the original price. However, Laila refused to sell the house, claiming that the offer was no longer valid. Now, the issue in this question is whether a valid contract exists between Aida and Laila. Specifically, does Aida's subsequent agreement to the original price of RM 500,000 constitute a valid acceptance, or did the earlier counter offer of RM 450,000 terminate Laila's original offer? On to the next slide, I'm going to explain about the relevant laws which can apply to this scenario. Under Section 2A of the Contract Act 1950, an offer is made when one person signifies their willingness to do or abstain from doing something with a view to obtaining the asset of another. Moreover, under Section 2B of the Contract Act 1950, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. However, according to the contract law principles, a counter offer amounts to a rejection of the original offer. Once a counter offer is made, the original offer comes to an end and cannot be accepted. This principle was clearly established in the case of Hyde and Range in 1840s. The defendant, Mr. Range, offered to sell the farm he owned to the complainant, Mr. Hyde. He offered to sell the property for £1,200, but this was declined by Mr. Hyde. The defendant decided to write to the complainant with another offer, this time to sell the farm to him £1,000. He made it clear that this would be his final offer regarding the property. In response, Mr. Hyde offered £950 for the farm in his letter. This was refused by Mr. Range and he confirmed this with the complainant. Mr. Hyde then agreed to buy the farm for £1,000, which was the sum that farm previously been offered. However, Mr. Range refused to sell his farm. The court dismissed the claims and held that there was no binding contract for the farm between Mr. Hyde and Mr. Range. It was stated that when a counter offer is made, this supersedes and destroys the original offer. This original offer is no longer available or on the table.
In this case, when Mr. Haid offered £950, he cancelled the £1,000 offer and could not backtrack and accept. Moving on to the next slide, to apply the law to the facts, in this scenario, Laila offered to sell the house to Ida for Rs 500,000, which constitutes a valid offer. However, Ida responded by offering Rs 450,000, which is a counter offer and not an acceptance. According to contract law principle, this counter offer legally terminated Laila's original offer. Laila then expressly rejected Ida's counter offer. At this point, there was no existing offer between the parties. When Ida later wrote back stating, "I agreed to buy at Rs 500,000, she was attempting to accept an offer that had already been terminated by her own counter offer. Since Laila did not renew or repeat the original offer, Ida's purported acceptance had no legal effect. Therefore, Laila was legally entitled to refuse the sale because no valid offer existed at the time of Ida's acceptance. In conclusion, there was no valid contract between Ida and Laila because the original offer was terminated by the counter offer. This situation clearly shows the importance of understanding that counter offer is not an acceptance but a rejection of the original offer. Thank you. To summarize our findings, based on issue 1, the situation involved clear offer and performance-based acceptance such as the Imnipart advertisement. A binding unilateral contract is formed once a condition are fulfilled and the promisor is legally obligated to perform. Secondly, where the claim is brought by third parties, the doctrine of privity of contract applies. Only the contracting parties can enforce the agreement. Therefore, under the issue 2 contract formed only between Rahman and Johan, Ida and Hafiz were not involved in the agreement. Furthermore, in family or domestic arrangements, the presumption is that there is no intention to create legal relation unless strong evidence proves otherwise. The promise made by Ida's mother is likely to be a domestic arrangement rather than intention to create relation. Therefore, there is no binding contract between Ida and her mother. Moreover, for statutory contracts such as government scholarship bonds, the agreement is legally enforceable and contractual obligation must be honored. Therefore, the bond is legally enforceable under Malaysian law. Ida is liable to repay the full scholarship amount despite partial service. Finally, where a counter offer is made, it legally terminates the original offer and no contract can arise unless a fresh offer is made and accepted. Therefore, no valid contract was formed between Ida and Laila. Ida's counter offer extinguished the original offer of Rs 500,000 and a later acceptance was ineffective in law.